Okay, so hi everyone. My name is Gil, and I'm a law and government student at Reichman University. In this presentation, I will explain what happened in our case, go over the important facts, and talk about the main legal issues and constitutional questions we looked at. Okay, so our case focused on Charlie. Charlie is a middle school student in West Virginia. She is a transgender girl. Charlie was assigned male at birth, but she has undergone gender affirm surgery, and now she lives and identifies as female. She used to be on the school cheerleader team and now wants to join to the girls cross-country team. However, under a recently passed West Virginia state law, students are only allowed to participate in sports teams that match to their sex assigned to them at birth. Because of this, Charlie was told she is not eligible to try out for the girls' team. This situation brings us some important legal issues and constitutional questions. The main legal question is it against the law to stop the transgender student from joining to the girls' sport just because of their sex they were given at birth? Okay, so to understand this, we looked at two key legal sources. First is the 14th Amendment that says that no state shall deny any person equal protection of the law. That means public schools, like Charlie schools, must treat students fairly and cannot discriminate without a strong legal reason. If a rule affects one group more than others, such as transgender students, it may violate this constitutional guarantee. The second one is the Title 9 is a federal law that says that schools that get money from the government are not allowed to treat students unfairly because of their sex. In recent years, USA courts have interpreted sex under Title 9 to include gender identified. That means discrimination against someone because are transgender can be considered sex-based discrimination. So in our case, the legal question issue is whether the school decision based on the state law conflicts with this federal protection, and whether Charlie identified as transgender girl should be legally recognized in context of the school sports. Now, we will go over the court cases we relied on and share our final recommendation for Charlie.
Okay, so today I'm gonna present a case that called BPJ versus West Virginia Board of Education. We're gonna use this case in order to strengthen our client Charlie's situation. So in BPJ versus West Virginia, the case is about a West Virginia law that called Save Women's Sports Act. This law means that basically only biological born females can participate in female sports activities. So it's basically discriminating all the trans girls community. So I'm gonna start with the material facts. In this case, BPJ is a 13 years old middle school student. She lives in West Virginia, and she was identifying as a female since third grade, since very young age. And also she is taking male puberty blockers, so she doesn't have any kind of male appearance. She tried to join the cross-country team, but got banned by her school because of that law. And now she she filed a lawsuit and claimed that both her Title IX and the Equal Protection Clause of the 14th Amendment got violated. The holding of the court in this case was yes, they agreed with her and with her claim that both the Title IX, which bans discrimination based on sex, was violated. The BPJ, she was in the same situation as all the other girls were in, and this is why she should participate in the sports team. She shouldn't be discriminated. And the under the 14th Amendment, the court used a legal test called intermediate security. That means that states have to prove a very strong interest in order to violate the gender fairness of participating in the school tournament. It means that like the states have to really have a strong interest against her, like if PJ is violating, if it's not fair for her to participate in the tournament, or if it's violating like any kind of public safety or something like that, a very strong interest. But in this case, the court found that the state didn't provide any kind of proof, and BPJ, as I said, took male puberty blockers, so she didn't have any kind of male appearance or any kind of male performance as an athlete or something, so it's fair for her to participate in the school activities. So she won the case. She got into the sport team, and I'm gonna relate it to our client Charlie. Charlie is in the same situation. She also lives in West Virginia. She also got discriminated by her school, and according to this precedent that she can claim that both her Title IX and the Equal Protection Clause of the 14th Amendment got violated. And in conclusion, I will sum it up and say I really suggest her to file a lawsuit against the state, and she can use this precedent, and she will win.
Bostock versus Clayton. I will start with the material facts. Bostock is a social worker. He works with children. And one day, he decided to join softball league, a gays softball league, which is important to remember and to know. And the job he was working at decided that they want to fire him. The cause of claim here that firing Bostock because of that violates Title VII, prohibition on sex-based discrimination. And the plaintiff seeks here is to get Bostock back on to his job, to pay back his missing wages, and of course to abstain future discrimination to other people or to Bostock. The legal issue here is, does discrimination against an employee for being an homosexual or transgender constitute discrimination because of sex under Title VII holding? The Supreme Court held by 6-3 majority that an employer who fires an individual for merely being a gay or transgender violates Title VII, prohibition on sex discrimination. Ratio decidendi, Gorsuch, for the majority, said that if someone is treated unfairly because of their sexual orientation or gender identity, the employer must be considering their sex, so it counts as sex discrimination. Rule of law, of course, Title VII, prohibition on discrimination because of sex. Price Waterhouse versus Hopkins, 1989. Onkel versus Sundowner, Offshore Services, 1998. Counter-arguments. So the main counter-argument here that some argue that in 1964, sex meant only male versus female status, not sexual orientation or gender identity.
Hello everyone. After reviewing the fact and the law, our team believed that Charlie has a strong legal case. Both the 40th Amendment and Title IX say that transgender students should not left out of school sports just because of the sex they were assigned at the birth. We studied 3 important court cases, okay? In both Stoke versus Clayton country, the US Supreme Court said that treating someone unfairly because they are transgender is a kind of sex discrimination. In Harris Funeral Homes, the court said that if someone is treated badly only because they are transgender, that is also against federal law. In the most similar case, BPJ versus West Virginia, the court decided that transgender middle school girl must be allowed to join the girls' cross-country team, even though a state law tried to stop her. This case is very similar to Charlie's situation. Based on all of this, we advised Charlie to first speak with the school and ask them to change their decision. If that doesn't work, she can file a complaint with the US Department of Education Office for Civil Rights. They handle cases like this. But if necessarily, Charlie can also take her case to federal court, just like in the PPJ case. To sum up, we believe that the school's decision to exclude Charlie is not only unfair, but probably also illegal. Charlie has strong legal reason to challenge the decision, and we believe she should be allowed to join the team. In this project, we learned that the Bill of Rights, the 14th Amendment, Title IX, and the Equal Protection Clause are not just legal words, they really help people, like in Charlie's case. The legal research was not easy. It takes time to find the right court cases and understand how to use them, but we did our best and learned a lot. Some of us were doing Army Reserve duty during the project. That made things harder, but we helped each other and got through it as a team. We worked all together. We shared the work, supported each other, and made sure everyone was part of the process. We are proud of what we did and what we learned. Thank you very much.